Thank you. Thank you, Robert. It is really my honor and my privilege to introduce the speakers tonight. Of course, Michael Lynk is our keynote speaker, and Jonathan I will introduce later before he responds. Michael Lynk is Associate Professor at the Faculty of Law in Western Ontario. He joined the faculty in 1999 and has taught courses in labor, human rights, disability, constitutional, and administrative law. He served as Associate Dean of the faculty between 2008 and 11. I first met Michael Lynk in Jerusalem during the First Intifada. In 1989, this happened in 1989 before he entered the academic world. Professor Lynk worked for the UNRWA, United Nations Relief and Works Agency in Jerusalem, as a refugee affairs officer. Subsequently, he has written several articles on international law and the Middle East conflict. Professor Lynk is a native of Halifax, a graduate of Dalhousie and Queen's Universities. Before becoming an academic, he practiced labor law in Ottawa and Toronto for a decade. Michael is vice chair of the Ontario Grievance Settlement Board and also acts as a labor arbitrator in Ontario. Professor Lynk has written widely on the issues of labor law and human rights in the unionized Canadian workplace. His writings have been regularly cited by a number of courts and tribunals. He has written extensively, as I said, and has co-authored numerous books. Examples: The Trade Union Law in Canada, International Law in the Middle East Conflict, a rights-based approach. He is also part of the academic team that produced the Labor Law Casebook, which is the national casebook used in law schools across Canada. In March 2016, the United Nations Human Rights Council appointed Professor Lynk as the 7th Special Rapporteur for the human rights situation in the occupied Palestinian territories. In this capacity, he delivers regular reports to the United Nations General Assembly in New York and the Human Rights Council in Geneva on human rights trends in the occupied Palestinian territories. Michael, we are so pleased you're here with us. We are looking forward to hearing you. Thank you.
Kathy, thank you for that generous introduction. And thank you to the organizers of the James Graff Lecture Series, and especially to the Reverend Robert Astley. Am I being heard double here? Put that away? Okay. Robert's been a long-time friend of mine, and for just as long, he's been a moral inspiration for me. No. Keep talking. Okay. I'm grateful for his invitation to me to deliver this year's lecture.
This techie guy is just adjusting it. He's got to keep talking so he knows what to adjust. He's just talking about Robert.
I'm grateful for your invitation to deliver this year's lecture, and I think we're all in debt for your steady hand in running this outstanding lecture series over the past decade. The invitation to give this lecture is especially poignant for me because it keeps alive the memory of an incandescent personality. Jim Graff was one of the very first people that I met when I first moved from the Maritimes to Toronto in 1984. I was lucky enough to be soon invited to join the wide circle of friends of Jim's and Aida's, who made their home a festive location for wonderful dinner parties, for December gatherings to decorate the Christmas tree, always a big favorite of Jim's, and for plenty of intellectual feasts and debates. I have many fond memories of Jim, but among my favorite was the 2-week visit that Jim made to Jerusalem and the West Bank in the summer of 1989, when I was working as a refugee affairs officer for UNRWA during the first Palestinian Intifada. During my off hours, Jim and I made a number of trips through the West Bank to witness the tragedy of the protracted occupation and the energy that was behind that uprising. Through these trips, I met an impressive array of Palestinians, Israelis, and internationals, all of them friends and associates of Jim's, who are working assiduously to try to bring some modicum of justice to a deeply unjust situation. Jim's range of contacts and friends in the OPT was astounding, and people were drawn to him, as I was, because of his resolute moral compass, his wry sense of humor, and his irrepressible determination to challenge the injustices that he saw in the world. Now, for someone who was trained as a contemplative philosopher, Jim was the very model of a person with moral energy. He was, as the French would say, engagé, someone with that fine sense of social passion blended with intellectual responsibility that we all aspire to. Now, before I begin the formal aspect of my lecture for this evening, I want to say a few words just about my role as Special Rapporteur and what it is that Special Rapporteurs do. And there are three features that I want to highlight. First of all, there are about 55 Special Rapporteurs. We're all appointed by the United Nations Human Rights Council for a term of 6 years each. We're all assigned to a specific mandate. Approximately 42 or 43 of the Special Rapporteurs have a thematic mandate, i.e. Special Rapporteur on housing, Special Rapporteur on food, on torture, on extrajudicial killings, and so on. And there are about 12 of us who have a geographic mandate, the Special Rapporteur for Human Rights in North Korea, Myanmar, Sudan, and the occupied Palestinian territory. We are unpaid volunteers, so we have to have day jobs that are flexible enough that allow us to spend the 3 or so months a year that it requires to be able to fulfill this particular mandate, which means that many of us are academics, we're professors, because we've got the flexibility in our job, and we've probably also got human rights training that allows us to be able to do this work with some modicum of expertise. We're appointed by the United Nations Human Rights Council, but in many ways we're autonomous or even independent from the UN and the Council in the sense that we choose our own topics within our mandate to report upon, and we decide what to say in those reports. We're expected to both be fearless and responsible in what we say and do. As well, in terms of what we're actually expected to do, we're expected to comment on the issues within the jurisdiction of our mandate. In particular, we issue 2 lengthy reports a year, and because it's the UN, they tell us we can't have more than 10,700 words exactly in our reports. And each report, and this is painful to an academic, to leave thousands of words on the editing table each time. So when I finished my report, just under the wire in early October, I had 10,697 words that I was... So I deliver these 2 reports, one report every March to the Human Rights Council in Geneva, and a second report to the General Assembly in New York in October. So to date, I was appointed in March of 2016. I took office in May of 2016. I've done 3 reports. The first report in October 2016 was on the right to development and the, I don't know a better word, but the strangulation of the Palestinian economy in the Palestinian territory. The second report in March was on the shrinking space for both Israeli and Palestinian human rights defenders in the work that they do on the occupation. And the most recent report, which was released last month and which is going to be the theme for my talk tonight, is on proposing a new legal framework for understanding the occupation. I should also say that I am not allowed into the occupied Palestinian territory. Every time I'm about to make a mission, I ask permission to be able to enter to the Israeli mission in Geneva. Silence is what I get in return. When I'm in Geneva, I ask to meet with the ambassador. I receive no response. The same thing is true with respect to trying to meet with the Israeli ambassador to the United Nations when I'm in New York. This is not solely confined to me. My immediate two predecessors also were denied entry into the occupied Palestinian territory, and the Israeli government has made it known that they don't recognize the mandate, and this is perhaps part of a larger quarrel that they have with the Human Rights Council. And I should say, as an aside, that this quarrel is going to become a little more public over the next couple of weeks and months. In March of 2016, I believe, the Human Rights Council passed a resolution based on recommendations from one of my predecessors that a database be set up with respect to businesses that work in or help finance the continuation of the settler economy in the East Jerusalem and the West Bank. There has been an immense amount of pressure, particularly in the last few weeks, put on the High Commissioner for Human Rights, both by the Israeli government and also by the American government, for this not to see the light of day. Those of you who may follow the newspaper Haaretz will know that there has been a series of articles in the last few weeks with respect to this, and I expect we'll see more articles on this. I have no reason to believe that there will be any significant delay in the release of that database with respect to organizations. The Human Rights Council, as far as I know, will not be taking any further steps aside from the publicity of that. And what happens to that then will depend upon the diplomatic community and civil society on the use of that make. But this comes within the context of a much broader conversation going on within the United Nations with respect to the issue of business and human rights. In fact, this past week there was a major conference in Geneva on that very topic, of which there were some significant side panels on the issue of business, human rights, and the occupied territories. So, turning to the theme of my lecture, reading the calendar of memorialized dates in the Israel-Palestine conflict is always a pitiless affair. And this is particularly so in years that end in 7, and even more so, in Novembers in years that end in 7. It was a century ago, November 2nd, 1917, that marked the issuance of the Balfour Declaration and the British endorsement of the Zionist movement's vision of a Jewish homeland in Palestine, a land at that time with an overwhelming Arab Palestinian population who also had national aspirations of their own. 30 years later, in November 1947, November 29th, 1947 to be exact, 70 years ago to the day today, the United Nations General Assembly adopted Resolution 181, approving a partition plan for Palestine that awarded a majority of the territory of Mandate Palestine, around 55%, for a Jewish state, although the Jews of Palestine at that time made up only about 32 to 33% of the population. And over the next year and a half, the struggle over Palestine would turn a fateful historical turn. On November 22nd, 1967, the UN General Assembly unanimously adopted Resolution 242, 5 months after the June War of 1967, when Israel had captured the remaining parts of Mandate Palestine, along with the Syrian Golan Heights and the Egyptian Sinai Peninsula. Resolution 242 affirmed the cornerstone principle of the inadmissibility of the acquisition of territory by war, which I'll be returning to in the heart of my lecture tonight. And in November 1977, Anwar Sadat traveled to Israel to initiate a peace process that would culminate in the Egyptian-Israeli peace treaty of 1989 and eventually lead to the return in full of the Sinai Peninsula to Egypt. But it would also involve the reneging of a commitment by Israel that was in the treaty to finalize the status of the occupied Palestinian territory within 5 years of the culmination of that treaty, and that incomplete peace process continues to haunt the Middle East to this day. And so here we are in November 2017. According to the International Committee of the Red Cross, the Israeli occupation now is the longest-running military occupation in the modern world. In his requiem speech delivered late last December for the Obama version of the Middle East peace process, U.S. Secretary of State John Kerry warned, and I quote here, "How would Israel respond to a growing civil rights movement from the Palestinians, demanding a right to vote or widespread protests and unrest across the West Bank? How does Israel reconcile a permanent occupation with its democratic ideals? No one has ever provided good answers to these questions," he said, "because there aren't any." John Kerry put his finger on the legal and humanitarian oxymoron that the situation has become, an occupation without end. And if I can ask to have the PowerPoint started. It's all there. You've got it. Okay. All set. So, I'm going to give a very brief background to the history of the modern conflict, beginning in 1967. And I know I'm talking to a knowledgeable audience, and I want to emphasize just a couple of points with respect to this. The June 1967 war resulted in the capture, as I said, by Israel of the West Bank, East Jerusalem, and Gaza, which was the remaining parts of Mandate Palestine. This resulted in a few weeks later, in the end of June 1967, by a cabinet vote of the Israeli cabinet, of the annexation of East Jerusalem. And parts of the West Bank. We're now marking the 50th anniversary of this occupation this past June, and the entire world community, the international community, considers Israel to be the occupying power. This is affirmed most recently by the Security Council in Resolution 2334, adopted on the 23rd of December 2016. It's also been reaffirmed annually by the General Assembly by overwhelming votes. The most recent one being in December 2016, UN General Assembly Resolution 7196. And the applicable law in the course of occupation then is the Fourth Geneva Convention of 1949, the 1907 Hague Regulations, the 1977 Additional Protocol, and a number of other supporting documents as well. It's been determined that laws of occupation also include international human rights law and international criminal law. Israel, virtually alone among the international community, refuses to recognize the situation as an occupation or its responsibilities as an occupying power. It refuses to recognize the application of the Fourth Geneva Convention, though it says it will apply the humanitarian aspects of the Fourth Geneva Convention, though I hasten to add that the entire Fourth Geneva Convention is embedded with humanitarian principles. The argument of Israel is that the so-called missing revisioner argument, that at the time of June 1967 war, that Jordan did not have a good sovereign claim over the West Bank and East Jerusalem, and Egypt had never claimed to have any sovereign authority over Gaza. Therefore, in the capture of the East Jerusalem, the West Bank, and the Gaza Strip, Israel says we have as good a claim as any, and perhaps a better claim under international law. I've got to say that there is no country that accepts this, and very few serious legal scholars accept this particular argument by Israel. So, the status of the international community's view towards Israel up until now has been to view Israel as the lawful occupying power, albeit an occupation that has a number of illegal features, such as the settlements, the construction of the wall in Palestinian territory, the annexation of East Jerusalem, and myriad violations of human rights. The question I pose in my most recent UN report, and I should say as an aside, the document, my report, is accessible on the UN website. Certainly if anybody wants to see a copy of it, if you have a card or an email address, give it to me afterwards and I'm happy to send it out to you. The report's been out for probably 5 weeks now, and the best, most gratifying emails I've had from people with respect to this are people who are interested in the question, but who are non-lawyers, and they said, you know what, I understood what you were saying, which sort of tells me maybe I was doing that wrong. Maybe I should have made it more complicated, more legalistic. No, but honest, I think anybody who has a broad interest in this particular question should be able to make their way through my report. I've tried to write it in a way for a very general audience, and I'm happy for the report to be shared as widely and as broadly as possible. So the question I pose in this report is, can a lawful occupant cross a tipping point, cross the bright red line to become an illegal occupant of an occupied territory? And if so, what are the consequences with respect to that? And there's no particular magic in the fact this is 50 years. It could have been that Israel crossed that bright red line after 5 years, after 15 years. I'm going to let somebody else figure that question out with respect to timing. What I'm saying is certainly at 50 years, we can ask that question and I think come to a reasoned answer with respect to that. And I should point out that international humanitarian law and the Fourth Geneva Convention do not set out a specific time period for when an occupation has to end. But what we can do is try to figure out what are the cornerstone principles of the laws of occupation and deduce from that the kind of answer that will tell us whether or not an occupation continues to be, or at least the occupant continues to be in lawful occupation or now becomes an illegal occupant. So let me take you through each of the 4 points. The first one is the occupier acquires no right or title to any of the occupied territory. This is one of the most well-established principles of international law since the end of the Second World War. When the framers of the new international order met beginning in 1949 and through a flurry of treaties and documents and declarations and conventions for the next 6 to 8 years as they were constructing the bones of modern international law, the most bitter lesson they learned from the First and the Second World War was that as long as a country can maintain as one of its statecraft policies the ability to look and change borders that surround it, we are going to be in an unstable war, an unstable society, an unsettled situation, and inviting future wars. So the conclusion of all that was we must have settled borders that all respect and none seek to enlarge or to aggrandize. So you look at the point from Resolution 2334 that was passed last December by the UN Security Council, reaffirming the inadmissibility of the acquisition of territory by force. This is, by my count, at least the 8th time that the Security Council since November 1967 has introduced a resolution with that foundational principle there. All of them, as it turns out, referring to the occupation of either Palestinian or Arab territory by Israel. And you can see in the other document that I quote, the Declaration of Principles of International Law Concerning Friendly Relations that was adopted unanimously by the General Assembly in 1970 is now considered to be part of customary international law. No territorial acquisition resulting from the threat or use of force shall be recognized as legal. And that applies whether or not this was a war of aggression, which captured the territory, or a war of self-defense. Now, there has been a lot of history written with respect to the June 1967 war, with some historians arguing this was a war of aggression, some historians arguing this is a war of self-defense. I don't need to take a position with respect to this to come to the conclusion that I've come to, because it's recognized, I think, regardless of whether or not it was a war of aggression or a war of self-defense, that an occupier under either circumstance could not acquire any territory as a result of that war. So that's point number one. The second principle is that occupations are inherently temporary, and the occupier is required to return the territory to its people, the sovereign, in as soon as reasonable a time as possible. In other words, occupations are temporary. They are not indefinite, and they are not permanent. In fact, a permanent occupation is a legal and humanitarian oxymoron. And you see the commentaries there. And the second one I just want to point out to you is that some of the best and most insightful recent writings on this have come from a series of very progressive, liberal, Israeli human rights scholars and international law scholars. One of the best is Ariel Gross, an international law professor, who writes that temporality, together with the principles of self-determination and non-acquisition of territory by force, is what distinguishes occupation from conquest. And this distinction would be thwarted were occupation construed as being indefinite. And when you stop and think of it, think of the major occupations in the post-World War that broadly adhered to these principles of occupation, of no annexation, occupations being as short as possible, and temporariness. I'll cite three for you. The American occupation of Japan after the Second World War lasted approximately 10 years, till about 1954 and 1955. The Western Allies' occupation of Western Germany from 1954 to 1945 to about 1955. Even whatever else we may argue about with respect to the American-led coalition war in Iraq in 2003, the American-led coalition was by and large out of there by 2012 or 2013, 9 or 10 years afterwards. So even with these long occupations, which were transformative occupations in the sense they meant to change the government and the legal and the political culture in those lands, the occupier was gone within 10 years. What do you say with respect to an occupation that is 50 years and counting? And I should remind you here that there was an interesting resolution passed back by the Security Council in June of 1980 on the 13th anniversary of the occupation. And in that resolution, UN Security Council Resolution 476, the Security Council said that it was alarmed at the prolonged occupation, and that there is an urgency to bring it to an immediate end, and that it strongly deplored Israel for its continuation of non-compliance with UN resolutions. That was almost a quarter of the time into occupation as we are now. That was 13 years. We're now at 50 years. So if that was the mood of the Security Council, and that was the language chosen by the Security Council in June of 1980, what do we say about an occupation that now is in 2017 and continuing to count? The third fundamental rule we take from the laws of occupation and international humanitarian rule is that the occupier, while it is administrating the occupation, is to rule in the best interests as a trustee or a fiduciary of the protected people. subject only to legitimate security interests of the occupying power, strictly defined. And there's a whole host of principles that we can derive from looking at the fortune. I can't believe this, that I would have left that phone on after expecting a warning to tell all of you to keep your phones off. Am I forgiven? Okay. Call declined. I will have to tell my son about his hockey practice tomorrow. But there are a range of strict obligations on the occupying power and a wide range of protections under international humanitarian law, such as the occupier must observe the human rights of the protected people during the course of the occupying rule. They must be working assiduously to return sovereignty and to realize self-determination for the people under occupation. They cannot pillage. They cannot rule in a self-serving or predatory fashion. There can be no collective punishment. There can be no individual or mass forcible deportations or transfers under this. And the fourth rule, the fourth and final rule, is that the occupier must rule in good faith. Good faith is a fundamental cornerstone of international law, as it is actually in domestic law in common law countries like Canada or Britain or the United States. And we find good faith being mentioned repeatedly in the foundational documents of modern international law, the Charter of the United Nations and the Vienna Convention on the Law of Treaties, among several others. And I argue, I submit to you, that there are two components to measuring the good faith of an occupier during the course of the administration of an occupation. One is that they have to comply with the supervision of the international community. And this means being in compliance with resolutions coming from the Security Council, the General Assembly, the International Court of Justice, which is the highest judicial body of the United Nations, and with the high contracting parties of the Fourth Geneva Convention. As well, it also means that they have to be in close compliance with all of the major obligations under international humanitarian law, which is the rule of governing conflict, as well as international human rights law as well. So those are the tests that point out how we judge an occupier. And these tests are not only going to be judging Israel and its administration of the occupation in the Palestinian territory. I submit this is a universal test. This would judge the test of any prolonged occupation. And while it's not in my position as Special Rapporteur to be able to point to other situations, others of you may think, well, what about the Turkish occupation of northern Cyprus going on over 40 years? What about the Moroccan occupation of Western Sahara going on over 40 years as well? And that's the law professor in me talking, not the Special Rapporteur. But those would also be the same sorts of tests you would wind up using to judge whether that is still a lawful occupant looking after that. And I want to point out to you, this is not simply the fervent imagination of a law professor sitting in a quiet study in London, Ontario, Ennui-on-the-Thames, as we fondly know of it, coming up with these magical thoughts. There is an important international precedent that I want to point you to. For those of us in the crowd, and I see some people who gray hair may match mine and may remember this, one of the most important rulings in modern international law by the International Court of Justice in The Hague was the 1971 advisory opinion with respect to Namibia. And I think there are very close parallels between South Africa's rule in Namibia and the Israeli occupation in the occupied territory. Let me give you a 2-minute history lesson with respect to Namibia. In the aftermath of the First World War, the League of Nations, a newly established League of Nations, granted mandate authority to a series of victorious allies, France, England, and in this case South Africa, to rule over the former territories of the Ottoman Empire and the German Empire. South Africa, under 1922, was granted the mandate to rule over what was then called Southwest Africa, the country we know today as Namibia. And the whole point of Article 22 under the Covenant of the League of Nations was that these mandatory powers, these European powers, or in this case South Africa, were to rule these territories in the best interests of the people living in those mandates, and were to lead them eventually to self-determination and to sovereignty as independent countries. After the Second World War, most of these mandates were still ruled by their European mandate holders and South Africa. And because of the demise of the League of Nations, the United Nations set up an international trusteeship system of which all of these mandates were to be transferred to. South Africa refused to transfer its mandate over Southwest Africa to this UN system. And there began to be a series of rulings coming from the International Court of Justice beginning in 1950, and I won't take you through that history. What's important is this. In 1966, the UN General Assembly adopted a resolution calling the continued South African role as mandate over Southwest Africa illegal. 4 years later, in 1970, the UN Security Council passed 2 resolutions adopting the same position, that the South Africa's mandate was illegal. And it did that on 2 bases. One was that South Africa was introducing apartheid and discriminatory laws into the rule of Southwest Africa. And 2, it was conducting de facto and in some cases de jure annexation of parts of Namibia. You may recall, for those of you who followed the tragedy and liberation struggles going on in South Africa in the 1970s, that there's a port called Walrus Bay in Namibia that had been appendixed to South Africa. And it was those 2 concerns, the introduction of apartheid and de facto annexation, which led to these resolutions. So the second of the 1970 Security Council resolutions asked for an advisory opinion from the International Court of Justice. And 9 months later, in June of 1971, the International Court of Justice came down with a seminal decision that is still studied today. Any of my law students who are taking international public law will spend a week studying the 1971 decision on Namibia. What it affirmed was this. It affirmed all these principles. The mandate holder has no right of annexation of any of the territory. It must act as a trustee. It must act in good faith. And it must act in the best interest of the people for whom it's ruling. And these territories, it said, cannot become the objects of disguised cessions. In other words, a disguised annexation. And the persistent and deliberate violation of these obligations winds up nullifying that continued mandate, and the international community is then to step in and remove the mandate power, in this case South Africa, from that. This didn't happen. The importance of the 1971 ruling from the International Court of Justice on this particular issue, besides setting out these principles, was to delegitimize South Africa's rule over Southwest Africa, over Namibia. Now, the tragedy is that wasn't sufficient to bring this to an end. It took another 19 years until 1990, a protracted guerrilla war, and intense bouts of diplomacy, largely led by Europe and the United States, to bring the liberation of Namibia. I say that there are actually a great deal of similarities between this particular situation and the Israeli occupation of the Palestinian territory. Yes, South Africa's rule over Namibia was authorized by Article 22 of the Covenant of the League of Nations, while Israel's rule is legitimized by the laws of occupation and the 14th Geneva Convention. But those, I submit to you, are different branches of the same tree. Both of them involve alien rule. Both of them must respect, both the alien rulers must respect self-determination and be moving unhesitatingly towards the achievement of self-determination for the people under either the mandate or occupation. Both cases, there is a violation of the principles of non-annexation, principles of best interests of the occupied people, and the temporariness rule. Indeed, when the ruling came down in 1971, by that time, the mandate, South Africa's mandate had lasted 49 years. The international community asserted its close supervision over South Africa and Namibia, but as I said, it took another 19 years for that to be achieved. So, the ruling, one of the important lessons from the ruling of the International Court of Justice in 1971 was its direction to the rest of the world. It recognized, and this is always a problem, it recognized that international law is not self-executing. International law requires a determined political and diplomatic will, in most cases, for it to reach fruition. And it was slow in coming, it was really only the Namibian people themselves taking armed struggle into their own hands that wound up achieving the liberation they had by 1990. But I also remind you of this. There's an article which I don't list up there, Article 25 of the Charter of the United Nations, and it says, the members of the United Nations agree to accept and carry out the decisions of the Security Council in accordance with the present Charter. That was quoted several times by the International Court of Justice in 1971 for the defiance that South Africa showed with respect to the rulings of the Security Council on Namibia. So, how do we apply those four principles that I've said to the Israeli occupation of the occupied Palestinian territory? Point number one, the no annexation rule. Well, we know that East Jerusalem was annexed first in 1967 by way of an Israeli cabinet decision, and then in 1980 by legislation through the Knesset. On both occasions, the General Assembly in 1967 and the Security Council in 1980 immediately issued resolutions, unanimous resolutions, demanding, stating that the annexation by Israel of East Jerusalem and parts of the West Bank was illegal and had no force or effect, and Israel was to immediately surrender that annexation. In August of 1980, Israel, and here I'm quoting from the exact language of the Security Council, the UN Security Council censured Israel in the strongest terms for its enactment of the basic law, affirming that the law was in breach of international law and that Israel's annexation was null and void and, quote, must be rescinded forthwith. Israel remains non-compliant with all of the United Nations resolutions on Jerusalem. There are presently about 210,000 Israeli settlers living in occupied East Jerusalem, and Israel has stated that it will not leave East Jerusalem. And beyond that, I also want to point out the issue of de facto annexation. Beyond Jerusalem, Israel is actively establishing the de facto annexation of parts of the occupied West Bank. For those of you who follow what's going on in the West Bank, you'll know that it's divided into three areas. Areas A, which is under partial Palestinian sovereignty, which is the populated Palestinian towns and villages in the West Bank. Area B, which is meant to be shared in terms of security between Israel and the Palestinian Authority. And Area C of the West Bank, which is 60% of the West Bank, which is where about 400,000 Israeli settlers and about 225 Israeli settlements live alongside about 300,000 Palestinians. And Israel has been treating Area C as its reserve land bank for the expansion of its settler population. The Association for Civil Rights in Israel has characterized Israel's regime in the West Bank, and this is a wonderful term, as a form of occu-annexation, which I think is a unique term that we can apply to the West Bank. In the West Bank, Israel exercises complete control over Area C, where its 400,000 settlers live in approximately 225 settlements. The settlers live under Israeli law in Israeli-only settlements, drive on Israeli-only road system, and benefit greatly from the enormous expenditures of public money spent by Israel in entrenching, defending, and expanding the settlements. Few of these benefits, except incidentally, flow to the 300,000 Palestinians in Area C. Only 1% of Area C is designated for Palestinian use, notwithstanding the 300,000 Palestinians who wind up living there. So the question I pose is, what country would invest so heavily over so many years to establish so many immutable facts on the ground in an occupied territory if it did not intend to want to remain permanently? Second point, then, is temporariness, 50 years and counting. And I say in my report that the only credible explanation for Israel's continuation of the occupation and its thickening of the settlement regime is to enshrine its sovereign claim over part or all of the Palestinian territory. And this is my words, a colonial ambition par excellence. Every Israeli government since 1967 has pursued the continuous growth of the settlements, and the significant financial, military, and political resources committed to the enterprise belies any intention to make the occupation temporary. Every Israeli government since 1967 has left office with more settlers living in the occupied territory than when it resumed office. The current Israeli government is strongly committed to deepening the settlement enterprise, and if I can use comments that were listed recently, just see if I can find this here very quickly. In Benjamin Netanyahu's cabinet, there is wall-to-wall support for the further annexation of all or part of the West Bank, together with solid opposition to the Palestinian state. This past January, just at the point in time when Obama was leaving office and Trump was entering office in the United States, Prime Minister Netanyahu said, "What I'm willing to give the Palestinians is not exactly a state with full authority, rather a state minus. This is why the Palestinians do not agree." Many of his ministers are even blunter. In mid-December, the Minister for Jerusalem Affairs, Zev Elkan, stated that Israel must plan for 1 million settlers in the West Bank in the next 10 to 20 years. He added, "Halas," and those of you who know Arabic know halas means enough. Halas with the story of two states. There is no other option but the state of Israel. Certainly between the Jordan River and the Mediterranean Sea, there will be one state. The third point that I list there is trustee or best interest. And I could cite a number of examples with respect to the violation of the best interest or trusteeship. And I'm going to cite just very briefly 3 examples. One is a shrunken economy, and this is the example from my first report done last October with the steady de-development of the Palestinian economy. You have to remember that the Palestinian economy, the Palestinians are not only splintered between 3 separately administered territories, Gaza, East Jerusalem, and the West Bank, but the West Bank itself is splintered up into 3 different areas, areas A, B, and C. And there are an estimated 165 non-contiguous areas of Palestinian area, which would count as areas A and B, of which not only is there difficulty for personal travel, there of course also is great difficulty in commercial travel as well. The ability for factory owners in Jenin to be able to create a factory for a market to be able to trade with the west of the West Bank, in Ramallah, in Jericho, in Hebron, in Bethlehem, is almost non-existent because of the 500 to 600 roadblocks that exist throughout the West Bank. We also are aware that there is an unequal legal and political rights in the same geographic area in the West Bank. There are separate political rights, separate legal rights, separate social rights, separate property rights, separate economic rights that are separate and unequal, that are distinguished solely on the basis of race and ethnicity. Others have used words, I don't use them yet to be able to describe that, but you can see where all of this may be heading. And the third point I want to raise is I've spoken briefly about Jerusalem and about Gaza. Much more could be said. I do not want to leave this lecture without making some reference to Gaza. Gaza, the Israelis' military forces left in 2005, but the world community continues to accept that Gaza is occupied territory. Israel has complete control over the air, land, and sea borders. Yes, there is an external border between Rafah in Gaza and the Sinai. But the thing to keep in mind is that Israel controls, and has controlled since the beginning of the occupation, the Palestinian population registry. Every Palestinian born, every Palestinian who winds up gaining or acquiring a status has to be able to go through Israeli authorities to be able to get any kind of birth certificate, marriage certificate, or travel documents. And Israel, through the use of its control of the population registry, controls even those who want to be able to leave Gaza through Egypt in a contiguous border that isn't directly controlled, but certainly is indirectly controlled by Israel. And I think the facts with respect to Gaza are disheartening today. Gaza is a community of 2 million people. I looked last month, and I wish I had brought it to be able to show you. I found a nighttime satellite photograph of the eastern Mediterranean. And Tel Aviv and Gaza are approximately 85 to 90 kilometers apart. They share the same sandy soil. They share the same blazingly hot Levantine summers. Tel Aviv is roughly 400 to 450,000 inhabitants. Gaza is 2 million inhabitants. When you look at these nighttime satellite photographs, you see this incandescent blaze of light over Tel Aviv, and you look down the coast, and you see these wan pinpricks of light in Gaza. Gaza needs, for its population of 2 million, around 500 megawatts of electricity a day. For most of the last 10 years, it's been receiving around 200 megawatts a day, which means power for 7 to 8 hours a day, followed by blackouts of 15 to 16 hours a day. But since April, and there are many fingers or many hands to blame for this, Gaza has been receiving between 140 megawatts down to 70 megawatts a day. And you look, if any of you look at Haaretz, the daily liberal Israeli newspaper, you will see that once a week or so it has a column which says, how much electricity did Gaza receive today? Gaza is receiving around on a series of rolling blackouts, it receives around 4 hours a day of power, followed by then 20 hours of blackout. Obviously, if you're richer, you will have diesel generators, be able to afford diesel, and now there are solar panels beginning to enter into Gaza, but those are almost always for private consumption. This has meant workplaces are shuttering because they don't have electricity. Hospitals are going through a severe rationalizing of their healthcare services because they don't have the fuel or the generators to be able to run a full hospital on that. It means that if there's no electricity, there's no water. So their water comes for a couple of hours every 3 or 4 days, and even more importantly, because of the lack of power, over 100 million liters of raw sewage is dumped into the Mediterranean every day, day after day. The beaches are foul. The fishing industry in Gaza is being decimated and young kids who swim in the water obviously are much more highly susceptible to waterborne diseases with respect to this. There may be hope with this current reconciliation process that some greater amount of power will be restored. But Gaza, almost alone of any economy in the world, between 2006 and 2016, the GDP actually contracted. And the irony is, it would have contracted even more had it not been for the 2014 devastation of war in Gaza, which flattened the center part of the residential areas of Gaza. The only uptick in the GDP has been the construction work to rebuild some of those houses. But there's still approximately 35 to 40,000 Palestinians who are still without housing 3.5 years later. So it's hard for me, I think it'd be hard for anybody to make a tenable argument that the occupier has been acting in the best interests of the occupied people during the course of the occupation. And the fourth and final point then goes to good faith. And I count over 40 Security Council resolutions since 1967 that where Israel is in non-compliance with. Resolutions that call for them to stop the settlement process and reverse it. Resolutions that call for them to end its sovereign claim over East Jerusalem and to stop the annexation of those areas. Resolutions that says you are an occupying power and you must apply in full the Fourth Geneva Conventions. Resolutions that say there are a myriad of human rights violations that are ongoing that you must bring to an end. Israel has been non-compliant, as I said, with over 40 of those. I count over 150 General Assembly resolutions that is also in non-compliance with along much of the same areas. My point is that if Israel, as a lawful occupant, wound up being in violation of any one of those four principles that I've mentioned, it would prima facie become an illegal occupant. I put to you that Israel is in violation of all four of those and is an illegal occupant. So as I close this, I ask, first of all, why is this important? It is an important legal question. It does require the application of law and international lawyers to come to this kind of conclusion. But more than a legal question is involved here as well. A profound moral question is involved. A profound diplomatic question is involved as well. One of the great paradoxes of international law with respect to the Middle East is this. On the one hand, there has been no conflict in the modern world that has generated so many resolutions of the United Nations, so much diplomatic oxygen being expended, so many hundreds and indeed thousands of articles written by learned legal scholars on the meaning of the question of terrorism, the legality of settlements, the meaning of occupation, the breadth of the Fourth Geneva Convention. On the one hand, the Israeli-Palestinian conflict has contributed mightily to our expansion of the knowledge of international law in the modern world. But the paradox is, international law at the end of the day is meant for the benefit of the people, particularly the besieged and the vulnerable. And they have been the last recipients of any benefits of these myriad of developments in international law. And if I can conclude with these particular remarks, international law is the promise that states make to one another and to their people that rights will be respected, protections will be honored, agreements and obligations will be satisfied, and peace with justice will be pursued. It is a tribute to the international community that it has sustained this vision of international law through its supervision of Israel's occupation of the Palestinian territory. But it is no tribute that as the occupation has deepened, as the occupier's intentions have become crystal clear, and as its defiance has grown, the international community has recoiled from answering Israel's splintering of the Palestinian territory and its disfiguring of the laws of occupation with the robust tools that international law and diplomacy provide. International law, along with the peoples of Palestine and Israel, have all suffered in this process. Can it be too much to hope that a finding of illegality by the United Nations General Assembly and the International Court of Justice, similar to the advisory opinion on Namibia, together with an international resolve to apply effective pressure points on Israel, would hasten the end of the occupation and the achievement of Palestinian freedom? Could this be done without the needless consumption of further bloodshed and the further erosion of faith in the efficacy of international law? Could this be an answer to the bitter smile of history? Thank you very much. I'll now invite Jonathan Kataib to come up here. Oh, sorry, there's an introduction to come first. Is it okay if I stay here? Okay, so please.
Michael, thank you so much. Is this on? Okay. Michael, thank you so much for this incredibly sobering but comprehensive lecture that you just gave. I think it leaves a huge challenge for all of us in this room. Thank you. I'd like to introduce Jonathan Kataib briefly. Jonathan is currently a visiting scholar at the Osgood School of Law at York University. He's a Palestinian attorney and human rights activist who grew up in East Jerusalem. He graduated from the University of Virginia Law School and is licensed to practice in New York, Israel, and in Palestine. Jonathan is the co-founder of Al-Haq, the first human rights organization that was ever established in the West Bank. He's also the co-founder of the Mandela Institute for Palestinian Political Prisoners. Both of these institutions are located in Ramallah. He's also the co-founder of many other institutions and organizations in civil society, including the Palestinian Center for the Study of Nonviolence in Jerusalem and the Holy Land Trust in Bethlehem. He is a member of the he's a member of the Bethlehem Bible College and a member of the Sabeel board in Jerusalem. He was a member of the committee negotiating the Cairo Agreement in 1994, the agreement on the Gaza Strip and Jericho, which led to the Oslo II Accord. Jonathan has written extensively and published on legal aspects of the Israeli military occupation of Palestine. He's taught human rights courses in several universities, including Bethlehem University and Al-Quds University. He is currently, he's continuing his work as an attorney in East Jerusalem and other parts abroad. Jonathan, please, we ask for your response.
Thank you very much. I was asked to respond to this wonderful lecture by my friend and colleague, I would say. And before I do, I want to make a quick reference to international law and how it is in fact created. This is important because not all of you, I'm sure, are practitioners of international law. And it bears to remind ourselves that international law is a work in progress. It is, in fact, continuously developing. Sometime around the middle of the last century, there was a huge push to create a system of international law. And there were three bases, three sources for international law. One was, of course, the practice of nations, how different countries act and react within an international legal system. The second was treaties and conventions, whether it's bilateral treaties or increasingly multilateral treaties where different countries would sign on to what was basically the canonization, the putting together of many of the principles and the rules that then became binding on everyone. But the third source was the writings of scholars, jurists, and others who would study the principles and put them down in a very authoritative, informative way, so that the writings of these scholars themselves become a source, albeit a secondary source, for international law. I mention this because, in fact, the development of international law was a very active, lively process which involved many people of goodwill, many academicians, many politicians, many people who cared about the future of humanity and who saw themselves slowly trying to build a new system whereby countries can coexist, can live together without the constant fear of war, without the constant fear of a rule of the jungle, without the constant feeling that the international community was an anarchy where every country would do what it wishes and where the powerful could always grab whatever territory they wanted and impose their will on the weak. Now, of course, we are still human. There are problems. There are lawless countries which behave contrary to international law. And perhaps the process of development of international law, which was so hopeful at one point, maybe it started to slow down a little. In fact, there was a lot of resistance, particularly by our neighbor to the south, but also others, to the creation of the International Criminal Court, which was another step in trying to develop international law. I view what we heard tonight and the report that it referred to as another attempt to develop international law in this particular area called belligerent occupation. You may not be surprised to know that on the issues of international law, there isn't really much disagreement. Even the highest court in Israel, the Israeli High Court, considers the territories, the West Bank and Gaza at least, to be under belligerent occupation. That is their status. They are not part of the sovereign territory of the State of Israel, and they do not choose to treat it that way. They waffle a little bit on East Jerusalem because as a domestic court, they are subject to Israeli laws and to the Israeli legislature, the Knesset, which has annexed Jerusalem, as well as the Golan Heights, by the way, but which do not treat these territories as occupied territories. And the Israeli High Court itself has waffled a lot as to how it should treat the Israeli occupied territories. So on the issue of international law, there really isn't that much conflict. The attempts to give the occupied territories a slightly different status so far have not succeeded. I remember one Israeli Professor David Kretschmer, about 30 years ago, who told me maybe the time has come to set up criteria for what he calls long-term occupation. He was very leftist in his leanings, and he thought that international law should impose additional burdens on an occupier for a long-term occupation than it needs to impose on a temporary occupation. That has not happened. And maybe what we hear today is an attempt to deal with an occupation that for all intents and purposes now openly and clearly intends to be permanent. Israel, under its current government, has made it clear, even the opposition Labour Party has made it clear, that settlements will not be removed. Even those settlers outside the so-called settlement blocks are going to be there permanently. The Israeli customs envelope, which includes Gaza and the West Bank, including East Jerusalem, the Israeli currency, which operates in all these cases, the population registry to which you referred, the postal union, the Wi-Fi system, the control over the borders at all levels, the underground water resources, the air, of course, above it, are all fully and completely under Israeli control. In a way, there is really only one state today between the river and the sea, and that state is the state of Israel, and it simply controls the Arab population there in different and varying ways. So this is the first point that I wanted to make in response. The fact is that under international law, we are facing perhaps a different situation. You are suggesting that it should be declared once and for all that it is illegal and proceed to try and eliminate it, and that is certainly one approach. The second point that I wanted to make, and it's perhaps a harder one to swallow. The second point is that the state of Israel faces a serious problem which I would call anachronism. Israel today would like to live according to the rules that existed in centuries past. It is part of the modern world in many ways, but in many ways it wishes to conduct itself as if it were occurring in a previous century or centuries. This is, of course, easy for religious people to understand, whether they are Israeli, religious Zionists, or whether they are Christian Zionists who hearken back to the times of the Bible. For them, the behavior of the state of Israel, if you do not take into consideration the modern world and international law, is basically quite good. In fact, on many issues, it is even progressive. It is even forward-looking. But we live in a different century. The second half of the 20th century, at the beginnings of the 21st century are a different historic epoch. Today, the concept of equality is supreme. We must remember that even 100 years ago, to allow women to vote was a great thing. Today, nobody even questions the need for full equality. Today, no one even questions that colonialism and imperialism are totally negative and should not be allowed. That slavery is illegal. That torture, under whatever term, is not only illegal, but a war crime and a crime against humanity. That there are certain principles where universal jurisdiction applies and where war criminals, especially after what happened during the Second World War, where there was very much felt the need to pursue and go after Nazi war criminals wherever they are and bring them to justice. So in this modern world, how does Israel conduct itself? For a while, a lot of effort was put into trying to create justifications, legal or moral, to allow Israel to do what it wanted to do under different pretexts. Well, we are in a defensive war, and therefore, if we acquire territory, that's not the same as if we conquered that territory. Well, we apply the humanitarian provisions of the Geneva Conventions, but not the political ones. Or, as the Israeli High Court itself would say, we apply customary international law because that's part of our law, but not the Geneva Conventions because these are treaties that need to be ratified by the Knesset. So there was some attempt to try and weasel around these things. Perhaps the good news is that with the current Israeli right-wing government, much less effort is being spent on trying to provide these justification. There is more a yearning for brutal return to rule of power. We do it because we can. It doesn't matter, the saying goes in Israel, what the Goyim say, but what the Jews do. What we do is what creates facts and not what people say. In fact, I even heard Netanyahu say that if international law is not in our favor, and maybe it's not, maybe we should change international law. The arrogance behind that statement I have not heard from other violators of international law. But the sentiment behind them is something that needs to be addressed. The international community, and if not the governments, then civil society, must find ways to bring about compliance with international law. Israel's security needs, whatever they are not enough to justify open violations of international law. And the international community needs to find new ways to enforce its principles and its values. I appreciate the power behind the lecture, the 4 principles that you have stated which Israel violates, but it is, I think, important to think how can we obtain compliance with existing international law and not how do we adjust international law even further to deal with these violations. But thank you very much for a very powerful lecture.
Well, this was brilliant. Thank you, Jonathan, for the response, and thank you, Michael. To have the UN Rapporteur on Palestinian rights here with us this evening is a real privilege and broadcast across the country. We're going to allow you to sit down for a couple of minutes before we take questions, if that's okay. And so in the interim, I'd like just while you have a moment to think about your questions, I'd like to say that we're grateful to Emmanuel College, which is part of Victoria University, which is part of U of T, for hosting us here this evening. They are a co-sponsor. And thanks to the endorsers. These are all the endorsing organizations, and they can be found on our website. Thank you for your promotion of this event and for filling this theater tonight. And I'd also like to thank all the volunteers who helped prepare this evening. And finally, we have in the envelopes you received an opportunity to get a tax receipt for a donation, and we're going to be passing around baskets if you'd like to make a cash donation or a donation by check. You can even write your credit card number on here with the donation amount, although there isn't a space for the credit card number. You can write it on here, and your credit card will be charged. Remembering that to keep our programs alive and to put on events like this, we do have significant expenses. So if you could pass around the baskets, please. And with that, I'm going to call up the volunteer coordinator for this evening, Talene Shaheen. Thank you, Talene, for everything that you've done to make this this evening happen. And Talene is going to be moderating the questions.
Thank you, Robert. Again, thank you, Michael Lynk. Thank you, Jonathan Kitab, for this insightful and informative lecture. So we're going to start the Q&A session now. We want a lot of questions. Yes. So we want a lot of questions. So for that reason, I ask that you please keep them short and concise. What we'll do is we'll take 3 at a time. Does that sound good? So we'll take 3 questions at a time, and Steve will let me know if there are any questions online as well. So if you have any questions, please raise your hand, and we have 2 mics floating around, and we will come to you. Again, please keep them short.
And friends, let me just add, it's much easier for the people in Edmonton to see you if you stand when you make your question, because if you're sitting, it's hard for me to see you on the cameras. Thanks.
Would you like to start, Steve, with a question from our audience afar?
I'd be happy to do that. Let me just put a camera on myself here so that they can see who's talking. Yeah, I've got lots of questions online already. I need to warn you. Let me start with the first one that came in. This is from Wendy Goldsmith in London, Ontario. And Wendy says, as an activist, it's often challenging to synthesize these observations and opinions into media bite-sized pieces. Okay. Upon which of these challenges do you think we'll have the most effect?
Okay, we'll take another question here.
Oh, hi. Thank you both very much. I'd like to talk about Canada's role in all of this, all the way back to Justice Ivan Rand casting the deciding vote on the United Nations Special Committee on Palestine, because our hands are very dirty in all of that, and we don't acknowledge it. But we've also voted against almost every UN resolution. And so I'd like your comments on that. Thank you very much.
So you're looking at me, the Canadian?
Yes, sir.
Okay. Interesting enough that the issue of Ivan Rand in 1947 was raised. This actually is a book project of mine. I've been interested for some years about 1947 and the United Nations' role in the partition of Palestine. I've been gathering a lot of primary documents, and it actually started because the law school where I teach, the Faculty of Law at Western University, the very first dean of the law school beginning in 1960 was Mr. Justice Ivan Rand, who stepped down at the age of 75 from the Supreme Court of Canada and then had another career then running the law school as the first dean until 1980. He was appointed as one of 11 international members of the United Nations Special Committee on Palestine in 1947. They had 3 months to be able to go to the region, do their investigations, go back to Geneva, and write a report. None of the 11 diplomats and jurists who were on that committee from a range of countries had any background or any expertise in the Middle East. They wound up going, after a month and a half in Jerusalem, Palestine, and then in Lebanon. They went to Geneva for the month of August of 1947, and I've read some of the notes of Ralph Bunche. I don't know how many of you know his name. Ralph Bunche was an African-American, very senior diplomat at the United Nations. He actually won the 1949 Nobel Prize for Peace in on the armistice talks between Israel and the Arab countries in the aftermath of the 47-49 war. In 1947, he was the secretary of the UNSCOP committee. And in his diaries, his private diaries, he talked about, I have never worked with a more contentious, more ignorant, more ill-informed committee than I have now with this. The long and short of it is, Ivan Rand was part of a majority of 7 of that committee of 11 to vote a majority report to endorse the partition of Palestine. There were 3 who voted against it, and all 3 of the minority reports had argued for some kind of unitary state, and there was one delegate from Australia who abstained. The majority report would have given actually 62% of Mandate Palestine to the Jewish population. They would have given them all of the main fertile land along the coast, a large part of Galilee, almost all of the Negev, and that was 62% for the 32% of the population that was Jewish. That was modified in the fall of 1947 with the final resolution of 181, which reduced that down to 55%. So yes, Canada bears a role, some may say a responsibility with respect to this. I'm more interested in what is going on now, and I would just say to you, all of you are aware of the particular foreign policy of the Harper government towards Israel and Palestine during the 10 years that the Harper government was in power. The Liberal Party has now been in power for a little more than 2 years, and I would tell you that 2 things have changed. They're important, I don't underestimate them. One was that the Liberal government restored most of the funding, Canadian funding, to UNRWA, which is an agency we've been involved in since the very beginning. The second change, I will say, is the tone. We don't have the same belligerent Israel right or wrong commentary that we had from the Harper government. It's a little more nuanced, but not much else has changed. If you look, what I think is the litmus test for how a country views the Middle East issue, look at the UN voting that takes place every December. And towards the end of the Chrétien years, Canada began to change its votes from no to either abstentions or to yeses. That began to be reversed in the Martin government. It was surely reversed during the 10 years of Harper. And the votes in December 2015 and 2016 under the current Trudeau government have not changed. I ask you to pay attention over the next 2 weeks as to the votes that will be occurring on the 8 or 9 resolutions dealing with the Israel-Palestine conflict to see if there's been any change. I'm not expecting any from the sources I've been given. That's something that has to be dealt with. And I should say one last thing with respect to this. You know, all that I've read, all that I've seen in terms of public polling and political decision-making on this issue over the last number of years, there is a distinct difference between what I call elite opinion, elite political and corporate opinion in views towards Israel-Palestine and the Canadian population, and popular opinion. That if you do polling among Canadians, their polling preferences are much more sympathetic to a just two-state solution and a wider sympathy for the Palestinians than you see in actions taken by Canadian governments in our foreign policy.
I think we missed the first question. I didn't quite understand what the...
Sound bites.
Sound bites?
Give us the sound bites.
You're asking 2 lawyers to talk about sound bites?
Okay. One very important sound bite is it's often claimed that Israel is singled out. And I think we must make it very clear that whatever position we expect of Israel, we also expect of every other country. If we say occupation is bad, occupation is bad. If we say collective punishment is wrong, collective punishment is wrong. If we say racism and discrimination is unjust, it is unjust. That is why we cannot allow ourselves to be caught up by people who want to support the Palestinian cause out of hatred of Jews, anti-Semitism. These are not the allies that we want. These people belong with the alt-right, with the Bannons, with the JDL, with the other people. On our side, we must emphasize that when we speak about justice, when we speak about rejection of racism, rejection of discrimination, rejection of apartheid, we are speaking for equality, and we are speaking for a non-racial, non-discriminatory society. So there's your sound bites. Rights are for everyone. Whatever solution, 2-state, 1-state, 4-state, no state, it must have an ingredient of equality. It must have an ingredient of non-discrimination. It must be a rejection of any violations of international law by any party.
Thank you. My question has to do, I'm sorry, well, I have the mic. Has to do to emphasize what Jonathan touched on in his speech, which if we look at the situation today, realistic, what's happening in West Bank and Jerusalem, for example, we have about 650 to 700,000 radical settlers, which of course they can be termed as none but Jewish Talibans. Those are people that every successive government, Israeli government, put them there in order exactly to eliminate that any solution will be done in order to give the Palestinians any proper property. So, and the occupation, maybe we should stop calling it occupation, because this is not an occupation, this is colonization. And it's going on not for 50 years, but for about 100 years. And in regard to Gaza, to my understanding, one of the reasons for the assault in 2014 on Gaza was in order to eliminate the talks of unity that was taking place between Hamas and the Palestinian Authority. Wouldn't Israel do the same thing this time if it really push come to shove and assault Gaza again?
I'll take one more, and then Steve, if you can.
I think that speaking at least as a lawyer, human rights activist, and I'm sure as a UN rapporteur you'd be agreeing with me, the principle of equality should be basic. If Jewish settlers claiming all sorts of things want to live in the West Bank, at a minimum, they should not have any privilege over Palestinians. At a minimum. Of course, we can say under international law, their very presence there is illegal, but at a minimum, they should be subjected to the same laws, the same courts, use the same roads, have the same rights or lack of rights as the Palestinians do. So that would force you immediately to either elevate the status of Palestinians or denigrate the privileges. This is really the litmus test. Are you there as conqueror, lord and master, or are you there for historic, religious, or other reasons, but are willing to live the same as everybody else?
Just go right to the next one.
Dimitri Lascaris. I'm going to ask you a lawyerly question, and it arises from the announcement within the last two days, basically, that the Trump administration appears set upon moving the United States Embassy to Jerusalem. And I'm curious, as a legal matter, we all have heard you say, and we know that the annexation of East Jerusalem is illegal. But what if the embassy were moved to West Jerusalem? My understanding is that under the partition, the whole city of Jerusalem had a special status that remained to be determined. What would be the legal implications of the United States or any other state moving its embassy to West Jerusalem? Would that be a violation of international law? Would that legitimize the acquisition of territory by conquest? What do you say to that?
My instinct is it's almost more a political question than a legal question. There is obviously from 1947 the conception that that Jerusalem was to be an international city. That, by and large, has become a dead letter, and the world has at least recognized that West Jerusalem is part of Israel, and that East Jerusalem is not part of Israel. It's been a political agreement among the international community that no embassies would move their embassy to Israel, to West Jerusalem, until there was an agreement on all final status issues and a durable peace agreement was going to be signed. Taking a precipitous step to move an embassy to West Jerusalem would be undermining that kind of consensus and would, I think, obviously favor Israel in showing that it can wind up getting the privileges of having an embassy in West Jerusalem without having to concede on the basic points in creating the just and lasting peace that that kind of agreement would bring.
Do you agree with that assessment?
Yes. I will also add that I do not expect that to happen anytime soon. Every single U.S. administration, however friendly to Israel, has resisted, even when the entire Congress would pass these resolutions requiring the movement of the embassy. It has always allowed the administration every 6 months to say that the time is not right. And for 30 years, the time has not been right. Even under Trump, the time has not been right, and it will not be right.
Okay, so we have another question from online, and this question comes from Hannah Strong, who's at Queen's University in Kingston, Ontario. And she has the kind of ordinary person in the street question. I keep looking, I can't look at you and look at the camera at the same time. But Hannah writes, I know there's no easy answer to this, but what can the average person do to ameliorate the situation in Palestine? She thinks of a few things that have been suggested in the activist circles, like supporting products made by Palestinians, continue the boycott, divestment from Israeli companies in the occupied territories. But you know, maybe those are suggestions, but how do we respond as ordinary people, I think is her question.
Yeah. I think that the BDS movement provides a very useful tool. It is a movement that is nonviolent and therefore does not address Israel's security concerns. It is a movement that's flexible enough that sometimes locally you decide to target one particular company or one particular event or one particular industry. Certainly those companies that benefit from the occupation or from the wall or that do business with the settlements can be legitimately boycotted or divested from without necessarily affecting the state of Israel itself. Calling for sanctions against war crimes, against violations of human rights, does not affect the essential security of the state of Israel. Maybe the BDS is flexible enough to allow people to in fact work non-violently for improving the situation without necessarily abandoning Israel's security interests.
I'll just add a few words with respect to this. There are prominent Israelis of conscience that we should be paying attention to. The Amos Shokin, who is the publisher of the liberal daily Israeli Haaretz, wrote a stunning piece almost 2 years ago now, where he said of his country's leadership, the only way, only international pressure will make them do the right thing. I listen as well to someone as esteemed as Haggai Elad, who is the executive director, the courageous executive director of Bet Salem, who gave an impassioned speech, which I urge all of you to find on YouTube, on Google, last October 2016, to the Security Council. And he said, he said, it's only your actions at the international level that will help change the political climate in Israel, that we can start moving towards peace. You know, and the thrust of what he was saying is, there are 13 million people who live in Israel, Palestine today. The population ratio is almost equal. Within a year or two, I suspect it will be equal, though we're not dead sure on the accuracy of current census. But the point of it is, the Israeli Jews are not going anywhere, and the Palestinian Arabs are not going anywhere. And the only future that all of them can have is one that's based on some measure of equality, some measure of human rights, some measure of non-discrimination. That is the only possible future all of them can wind up building. There are a small but significant number of Israelis who recognize that as well and envisions that same kind of equal or common future together. We have to pay attention to them, and we have to wind up finding ways of supporting them as well.
Yes, I'd like to ask a question. So basically, there is no controversy about the substance of international law. Even among the two of you and virtually everyone, it seems, there is no controversy about the substance. However, what about the application of international law? That just does not seem to be happening when it comes to Israel, particularly when you mention that the Security Council itself had 50 resolutions. I mean, there's the difference between the General Assembly resolutions and Security Council resolutions. What is to be done when international law cannot be applied?
International law is, I'll build upon what Jonathan has said. In a world that's divided by race, by religion, by ideology, by class, by vast cultural differences, international law is the human-made creation of a common language that reflects our moral standing at any particular time. It is the single most useful tool and weapon and form of language we have with each other, because every single country in the world has at least ostensibly agreed to buy into international law. So maybe my own bias, but it seems to me it's a powerful, not only a powerful legal tool, it's a powerful advocacy tool when something is wrong and deemed to be wrong under law, to be able to point out to those who make decisions diplomatically and politically that that has to be rectified because international law winds up not being obeyed. And you're perfectly right with respect to that. When you have a long-time defiant, non-compliant country who's ignored resolution after resolution, after a while, criticism without consequences becomes meaningless. I don't want this to be the answer, but stay tuned. I've given you an analysis of the legality of Israel's role as occupant. I plan in a year's time, in not my next report, but my report after that, next October, to actually look at what tools of international law, international diplomacy are available for these sorts of situations. And again, it's something that would apply to Israel, but not only to Israel. You know, any country in a long-standing non-compliance with the demands or requirements or obligations of the international community would come under that same law. There's common articles under the 4 Geneva Conventions. There are rules with respect to third-party obligations. The essential rule is that the international community is not allowed to leave a situation once declared as illegal to remain illegal. There's supposed to be forms of international cooperation to bring that to an end. You can speculate and I can speculate for all the reasons why this has never been done in the case of Israel, and that it continue to deepen and entrench the occupation with impunity. But you know, legal exceptionalism is a dangerous commodity in the modern world. For one country or for several countries to be able to point out the laws of the world apply to everybody else, they don't apply to us, is a sure way of undermining this fragile but important system of rule by law that we've created since the Second World War.
Hi there, thank you very much. I think the elephant in the room is that we can talk about law all that we want, but as long as the United States continues to bankroll Israel and its military, essentially you have not only belligerency and a belligerent occupation on the part of Israel of the Palestinian territories, but you have a belligerent nation in the form of the United States, which itself could be and has been described as the largest terror organization, or its government in the world. I just wanted to get your reaction to the following concept. You drew the analogy of South Africa and Namibia. I think another very apt analogy is in the southern United States under Jim Crow law. And as Israel/Palestine, whether we think of it as one day, 2 states, or it's one state, it reminds me a lot of that with people of color drinking from separate drinking fountains and riding on the back of the bus and being subject to separate laws. And I think that is an analogy we should be leaning on a little bit more from time to time.
Yeah, I have no problem with that. I think it's important to know that no matter what are the forces that are preventing the application of international law, eventually reality catches up with you. History catches up with you. The arc of history, Martin Luther King Jr. used to say, may be long, but it bends towards justice. In our case, we have a situation where there are very powerful forces that can affect and influence at the top 1%. I am glad for independent Jewish voices because they make clear that whatever these forces are, these Zionist forces don't speak for Jews. They speak for a Zionist movement that right now may be very powerful, but eventually it cannot prevail. If even in the United States, for all its problems, where African Americans were even enslaved, outright slaves, there had to be a civil rights movement, and there had to be radical changes, maybe not completely successful, but quite successful to the point where you had a US president in Barack Obama. Doesn't solve all the problems, but the movement of history is very clear, and I can't see Israel resisting that movement of history forever. Forever is a very long time.
And if I can just add very briefly, go back 30 or 35 years, which is when I first went to the Middle East as a young law student. and think of the changes that occurred there since, notwithstanding the opposition of Israel and notwithstanding the diplomatic support that the United States gave to Israel. The Palestinian people between the early 1980s and now have been recognized as a people. They have their political organization, the PLO, was recognized and given status internationally. They've been recognized as a state by 138 countries in the world. They are recognized as, if not the more powerful, certainly the more powerful party to the negotiations. They at least have a veto over any final resolution with respect to this. So if we're to sustain some optimism that things can change, notwithstanding the forces that are allied against us, I think we have to pay close attention to the historical accomplishments that have occurred, along with the defeats that have been suffered.
Okay, sorry, this will be our last question. Unfortunately, we're way beyond time.
We sure are, and let me tell you, the folks online have been so grateful for the opportunity to be a part of this. I'm going to put together two questions, one from Scott in Edmonton, and the other from Leo in Ottawa. Scott's acknowledging the comments you made about Namibia, and he says, in that case, the US and the UK were on side, and they don't seem to be in this one. Mm-hmm. So what hope is there? Yeah. And Leo is saying something similar. Leo's just come back from Israel and feels like the situation, the positions are so entrenched there that again, he doesn't see much hope. So he'd love to have send us out on some hope there, would you please? Okay,
I'll answer the first one and I'll give the second one to Jonathan. With respect to Namibia, he's certainly right that the United States was on the side of Namibia in those questions in the late 60s and early 70s. Great Britain actually was not. Great Britain was much more closely tied to South Africa than it was to trying to bring an end to the South African mandate over that. The world has changed substantially since then. You've got to remember, in the late 60s, you were just beginning to receive the flood of countries escaping colonialism into the United Nations. We now have, since probably by the end of the 1980s, an extraordinary block of countries from the developing world or the third world, many of whom are important supporters of Palestine and want to be able to see it finally achieve independence. So if there is difference between, and obviously all historical analogies are never perfect, but I think they're close enough with the new degrees of support that the Palestinians have. 138 countries out of 193 recognize Palestine as a state. That's roughly 60% of the body. So if there is a serious motion to go to the General Assembly, to ask for an advisory opinion, to go to the International Court of Justice, and if the Palestinians see that as in their interests, I think that will happen.
I'd like to address that question. I always make a clear distinction between optimism and hope. You're right, the situation does not look optimistic at all. The situation is very dire for the Palestinians. They are fragmented, they are separated, their leadership leaves a lot to be desired, their opponents seem to be totally powerful, their so-called allies in the Arab world sometimes worse than their enemies. So the situation immediately on the ground looks helpless. What can we do? We can't be optimistic. Nothing is going to change. There is no election that's going to come that is going to bring in a progressive Israeli government at all. If Netanyahu leaves power, he'll probably be replaced by somebody more to the right wing. That's where the movement in Israel is. On the other hand, and I can say this because we are in a chapel, there is hope. There is hope. There is hope, and Palestinians have hope. They have hope in God, they have hope in history, they have hope in the movement of history, they have hope in the legitimacy of their cause, they have hope in people like yourselves all over the world. who, without being anti-Jewish, are very much pro-Palestinian, who recognize today Israel not as the underdog, but really as the oppressor and the occupier, who acknowledge today what we didn't dare to mention 30 years ago, that Israel uses torture and collective punishment and administrative punishment and imprisonment systematically, that are destroying and demolishing Palestinian homes while they're building more and more illegal settlements. This is now known by everybody. We don't have to prove that the occupation is bad or is illegal, or that Palestinian rights are being denied, or that the Palestinian people are being oppressed. That is no longer an issue. The issue is, how can we bring about a better society without sacrificing the real legitimate interests of Jewish Israelis who are living in Palestine today. Under whatever conditions, they are there and they are living there. The question is, can we bring a measure of justice, of equality, of respect for human rights, of dignity, and a better future for both people? This is the struggle, and if the governments aren't willing to get on board, this is where civil society and people like yourself have a very important role to play, and eventually, I am certain of victory, not victory of one side over another, but victory for justice, victory for equality, victory for a non-racist, non-exploitative future for both parties.
Amen.